Biow Chuan.
Sir, I declare my interest as a lawyer whose practice involves matrimonial law. There are two parts of this bill which I wish to speak on. The first is Clause 35, which talks about the enhancement of enforcement powers relating to access to a child. Clause 35 of the bill introduces a new sections 126A and 126B to the Women's Charter. These two sections seek to enhance enforcement powers of the court relating to custody and child access orders. In principle, I agree to the provisions of Section 126A of the bill. However, I would caution that before making any order to the bailiff to seize a child, the court should consider taking action against the parent who is in breach of the custody order. Seizure of a child, especially if the child is of tender age, must be done in a sensitive manner so as not to cause any emotional trauma to the child who is caught in the dispute between parents. I also support the provisions of Section 126B. This new provision will allow an aggrieved parent legal powers to enforce his or her rights to access to the child. I believe that most matrimonial lawyers will have come across cases where one party was granted access to his or her own child, referred to in this bill as Party X, has faced difficulties trying to gain access to that child. Sometimes this is because the other party, the other parent, Party Y, feels that depriving Party X to access is a way of getting back at Party X. And Party Y feels that by not allowing the ex-spouse to see the child, he or she is punishing Party X. There are also cases where Party Y may threaten to prevent Party X from seeing the child unless Party X concedes to the demands by Party Y. In other words, the child is used as a negotiating tool to compel Party X to back down. So such situations like this cannot be acceptable because it hurts the innocent child to be caught in a fight between parents. The child should not be used as a negotiating pawn in disputes between two warring spouses. Any parent who chooses to breach the child access order would have to face the consequences. I also support granting powers to the court to order parties X, Y, and the child to attend compulsory counseling so that all involved parties can understand that it is in the best interest of the child to grow up with both parents who love and care for the child. This is better than having a child grow up resenting and hating an absent parent who has been deprived of access. Many matrimonial lawyers would have also come across cases where one parent tries to poison the mind of the child against the other parent by constantly saying negative things against that parent without care and control. In such cases, providing the court with power to order the parents to attend educational program and for the child to attend a therapeutic program or family support program is an option that will mitigate the toxic effect of the poisoning of the child's mind. So I have two queries about this Clause 35. First, the new Section 126B3E provides power to the court to sentence a defaulting parent to a fine or imprisonment term. In my view, where a parent in default is recalcitrant, the court's power to impose a fine or sentence to incarceration will serve as a strong deterrent, not to disobey a court order. However, sir, I'm mindful that there may be occasions when an older child may refuse to see the other parent due to previous negative experience of being physically or emotionally abused, or that child may witness his parent, Y, being abused by parent X. Hence, if the child grew up filled with anger against the abusive parent, he may resist any order for access granted to the child who was abusive. In situations like this, I hope that the judge hearing such enforcement applications will exercise discretion to interview the child or appoint a counselor for the child to hear the child's point of view before making any order of fine or imprisonment. I hope that the court will be able to discern the circumstances where an access order may not be practical due to an abusive parent. We should not allow an abusive or vindictive parent to abuse the legal process and commit the other parent to jail. Second, on this Clause 35, may I ask the Minister of State whether we have enough counsellors to help divorcing parents deal with the issue of access. Counselling can be a long-drawn process And with about 7,000 divorces every year, these counsellors will be stretched if there are not enough trained counsellors to share the workload. When the Family Court introduced Compulsory Mandatory Parenting Program, or MPP, I thought that the MPP would have counsellors who can help couples think through the process before applying for divorce. However, I was told that MPP is a short session to advise the applicant on the need to make provisions for the child of the marriage. I'm certainly glad to hear Minister of State say that the MPP would be enhanced to provide more support to couples thinking of divorce. So, sir, I urge the ministry to provide more resources to counsellors so that we can do more to assist couples who are contemplating divorce to review their options and also assess the potential impact on the child before proceeding. So next, I wish to express my concern about Clause 29 of the bill, which introduces a new Section 95A(1)(f). This new section provides a new ground for parties to apply for divorce if parties X and Y agree that the marriage has broken down irretrievably. What is described by MSF as divorce by mutual agreement, or DMA. Now, in 2016, the then Minister for Social and Family Development summed up the government policy as follows: Singapore is our home for family. Strong families are and must remain the basic building blocks of our society. In the coming years, my ministry will continue to strengthen fundamental family relationships and support vulnerable families. So if you find this familiar, sir, this speech was made by you when you were then Minister for Social and Family Development. So my understanding of a family in Singapore is that it constitutes a married couple with children, and they form the usual family structure in Singapore. Thus, if government policy is to have strong families, which are the building blocks of society, then I submit that the government must do more to promote the institution of marriage, so as to strengthen parties' commitment to marriage. A marriage is a serious commitment by two parties to enter into a union with one another. In most marriage vows, each party will minimally undertake or pledge to the other that they will love, comfort, honor the other party in sickness and in health, so long as they both shall live. Any couple who has been married for several years will share that it requires much effort by both parties to make a marriage work. Even for happy marriages, there will always be the inevitable quarrels or disputes over finances, lifestyle, upbringing of children, and even relationship issues involving the in-laws, and this will shake a marriage. My concern is whether the new Section 95A(1)(f) will make it easier for couples who cannot work out their disputes to take the easy way out and apply for divorce based on mutual agreement. In a written response by the National Council of Churches of Singapore, NCCS, in June last year, NCCS expressed concern that some couples may see the amicable divorce option as providing an easy exit that will allow them to run away from their problems without having to assign blame. Thus, instead of trying to find solutions to their problems as a couple that have pledged their lifelong commitment to one another, that husband or wife may simply decide to end their marriage. So I share the same concern as NCCS. I'm not anti-divorce. I recognize that sometimes despite the best efforts, marriages don't work for a variety of reasons. In such cases, the law should allow couples to exit from an unhappy marriage. The current laws recognize that when marriages don't work, parties can file for divorce because the marriage has broken down irretrievably. Because the marriage has broken down irretrievably. Currently, there are 5 possible grounds which constitutes irretrievable breakdown of marriage. 3 of these grounds are what divorce lawyers commonly call fault divorces: adultery, unreasonable behavior, and desertion for a period of 2 years. These are the factors that cause the irretrievable breakdown in marriage: a party's adultery, a party's unreasonable behavior, or a party's desertion. The other 2 grounds are what we call no default divorces, which are based on separation for a period of 3 years with consent, or separation for 4 years even without consent. It is the period of living separate and apart which causes the marriage to to break down. Some members of this House may recall that in the 1970s, parties applying for divorce based on separation were required to live separate and apart for an even longer period of 7 years. 7 years. So over these years, there have been changes to make divorce easier by shortening the separation period. Thus, in actual fact, parties can divorce without apportioning fault, except that they need to wait the statutory period of 3 years or 4 years. In 2015, the courts had introduced the simplified track for divorce, where parties who are able to agree on the terms of divorce and the ancillary matters can have their divorce application dealt with expeditiously. Thus, for parties who wish to settle their divorce cases quickly, a simplified track divorce is already an option where parties have to be less acrimonious if they want their divorce to proceed smoothly. They still need to cite one of the 5 grounds when they file for the divorce, but most parties will come to a compromise on the grounds of divorce. Straits Times reported on 8th of November last year that simplified track divorce account for 60% of the divorce applications filed. For cases where parties are unable to agree and wish to contest the divorce, the courts will usually call both parties down for what we call a status conference, where the judge will invite parties to review their position whether to have an acrimonial contested divorce. Frequently, both parties will eventually accept that if the marriage has broken down, then a contested divorce will not serve anyone's interests. This is because winning a divorce basically means that parties remain married, even though they have undergone a contentious divorce hearing, and that doesn't make sense. So the current divorce rates in Singapore have remained fairly constant at about an average of 7,424 cases for the last 5 years. That means 7,424 per year for the last 5 years. Last year, there were 6,959 divorces and 22,651 registered marriages. And the year before, there were 7,623 divorces with 25,434 marriages. Given the above facts and circumstances, may I ask the Minister of State, why is there a need to introduce this new clause to allow divorce by mutual agreement? What is the change in circumstances that trigger the need for the introduction of this provision? Does the government not acknowledge that the divorce may have serious consequences for the children? And some years back, MCCY, as it then was, used to produce pamphlets on divorce. Before you divorce and how to survive, children and divorce. And these pamphlets highlight the real issues about divorce. One particular pamphlet stood out to me, so this is for members of the House who are interested. And this pamphlet says, at some time in the marriage, problems will arise. Some of these problems seem intractable, others do not. For the problems that seem intractable, people often think that divorce is the answer. And he concluded with the word, think again. Think again. So this pamphlet is available to parties who wanted to file for divorce at the time. And it really urged couples thinking of divorce, think again. So may I ask the Minister of State whether she will agree that allowing a divorce based on mutual agreement may inadvertently undermine the marriage vow and parties' commitment to the institution of marriage. A vow to commit to a marriage can now simply be revoked by mutual agreement to divorce. Has the government made any study of the experience in other countries which allow divorce by mutual consent? NCCS cited a study that said that after the first no-fault divorce that was adopted in California, there was a persistent decline in marriage rates, accompanied by more single parenthood, and cohabitation. Would allowing a divorce by mutual agreement result in an increase in divorce rates? What if this amendment does, in actual fact, result in divorce applications going up by a large number in the next few years? Would there be more single parenthood? How would the government then try to arrest the increase in divorce numbers? Because it may be impossible to turn back the change. In a media release by MSF, the government cited that there was strong feedback against having to cite fault against the other party and having to dredge up the past just to prove the facts. However, Section 95A(6) still requires parties to state in writing the reasons leading X and Y to conclude that their marriage has irretrievably broken down, and their efforts made to reconcile. When parties have to cite the reasons for concluding that the marriage has broken down irretrievably, it will be inevitable that there will be some accusations against the other. I also hope that the government is cognizant that divorce by mutual agreement does not mean that there will not be acrimonious litigation. Parties could still fight tooth and nail regarding custody, care, and control over the children. They still fight over the division of assets, and they also fight over maintenance. Sadly, sir, divorce is a very emotional process where parties frequently felt betrayed, and the acrimony is always there. Sometimes when parties acknowledge that no one is at fault, but they nevertheless want a divorce due to incompatibility or for whatever reason, the advice that can be given to them is to live separate and apart, and to meet the legal criteria for divorce based on 3 years or 4 years separation. Sometimes parties may want a divorce due to misunderstandings, due to failure to communicate, due to quarrels over issues which they feel emotional about. In situations like this, separation may allow parties time to cool down, to review their reasons for wanting a divorce. That separation may not always lead to reconciliation between the parties, but a divorce does have a massive impact on the parties, especially when young children are involved. If parties are open to attending marital counseling during their separation to help them work out their differences, sometimes the marriage may be salvaged. The government has to strike a balance between making it too difficult for parties to get a divorce in failed marriages versus making it too easy for couples to give up their commitment and call it quits when they encounter difficulties in their marriage. I seek the government's assurance that we are not taking the latter approach. I ask the Minister of State to assure members of this House that the government is committed to promoting and strengthening marriages between couples, that the government has no intent to allow couples to give up on their marriage too easily. We can do more to build up the institution of marriage in Singapore. Thank you, sir.